Hello, my name is Habiba Osman. I work for Malawi Human Rights Commission in Malawi. The Commission is a national human rights institution, which is a constitutional body with administrative and functional autonomy. The mandate of the Commission as provided for in the Constitution is really broad, encompassing the promotion, protection, and investigation of human rights in Malawi. Malawi Human Rights Commission, our work, the starting and ending point for the work that we have been doing on the death penalty is that we recognize, as well as the Constitution recognizes, that the right to life and other basic rights are often breached in the application whenever the issues of the death penalty are brought to the fore, or if the country has it on its statute books. Of course, in Malawi, we haven't had anyone in the past years, I think, committed to the death penalty, but it has been found to still be a breach of the prohibition against cruel, inhumane, and degrading treatment. And though in Malawi, it is not applied as it were, but it is still on our statute books. So recently, with the ruling by the Supreme Court, when they abolished the death penalty, it really has opened up a very interesting debate, but at the same time, the ruling has brought in some promise and hope that those who were even sentenced to the mandatory death penalty and had been barred from resentencing will have really new opportunities. Again, for advocates like some of us who are working in the human rights field, it's also a new beginning, because now what we are pushing for is that there must be new sentencing hearings immediately. So the ruling has created a critical momentum for conversations about abolition that is also taking place across the Southern and Eastern Africa region. And it is hoped that this ruling from Malawi will give a huge and positive boost to other countries across the region, especially when it comes to positive repercussions. So today, I'm so excited that we will be on this panel, and we'll be hearing from other human rights experts from Malawi, Zambia, Tanzania, and Kenya on the vital work they are doing in their own countries and the opportunities for abolition across the region we are now. And just a quick rundown of our speakers as well to complement the ruling in Malawi is Alexius Kamangila, a lawyer, activist, and reprieve fellow in Malawi. He will be explaining how the abolition of the mandatory death penalty and the subsequent resentencing process lay the foundations for the total abolition of the death penalty. Again, it is expected that we may have also Winfred Simboya, lawyer, activist, reprieve fellow from Kenya, who also give an overview of the recent abolition of the mandatory death penalty and the complexities of conducting a resentencing process for over 5,000 death row prisoners. Winnie will also explain the impact, if any, of the decision in Malawi on the work of abolition advocates in Kenya. So we will have a Kenyan perspective in that regard. And then Fulgence Masawi is also expected to join from the Legal and Human Rights Center in Tanzania. We'll also speak about the work of the Eastern African Coalition against the death penalty and the death penalty abolition efforts in Tanzania. And we'll also have Kelly Kapiyanga, a lawyer, and Mwiba Mwenda from the Zambian Law Development Commission, who will then speak about the status and the mandatory death penalty in Zambia, the prospects for reform, and the impact, if any, of the decision in Malawi on conversations about the death penalty in Zambia. Again, we hope to conclude the session with a Q&A with our esteemed panelists. Thank you very much and welcome to this session. And also, we thank our sponsors who have also sponsored this session. Thank you. Over to you, Alexius.
Thank you so much, Habiba, for that brilliant introduction and for your kind words in your introduction. As indicated, I'm going to have a discussion or a conversation on brief context within which the Kovua decision is found upon. And thereafter, to talk about the advocacy towards abolition of the death penalty and how the decision might have an impact, not only in Malawi, but in neighboring countries. So in 2005, a petition on the question of the constitutionality of the mandatory death penalty was brought before the High Court, sitting as a constitutional court. And as they were deciding on this question in 2005, in 2007 rather, the Cavantine decision, the court decided that the mandatory death penalty was unconstitutional. Now, just briefly, the mandatory death penalty was that which a process where someone was convicted of murder, there was no consideration of the circumstances within which that offense was committed. So it was automatic death penalty. That was under Penal Code Section 210 then. And so upon this decision, there was a consequential order in addition to the declaration of the mandatory death penalty as unconstitutional, which was that all people that were currently on the death penalty at that time were supposed to be brought back before the High Court for an effective remedy. So everyone was supposed to be heard on their circumstances. An order under Section 46, subsection 3 of the Constitution of Malawi. And it was this, what would be now termed as the Cavantine Resentencing project. And within this process, this provided a room for the people that were representing different death row inmates to provide in sort of mitigating factors within which the court was supposed to consider. And that entailed that people, paralegals, and different stakeholders were supposed to go back to the villages of these people that were on the death penalty so that they could get their stories. So from the beginning, you would see that now a criminal who was just considered as a murderer, now a story was being developed, a picture, the humanity in the person was coming out once the paralegals had gone to their villages to find out their childhood, to find out what transpired, to find out what happened and who they were before the crime that they were associated with occurred. So basically, this resentencing process was able to tell the story that death penalty can never be justified because people now saw the humanity in the criminal. And the success of the resentencing project as well was so overwhelming that no one was resentenced back to death. And the majority of people had been were released immediately. And connecting to the resentencing project and advocacy in general, as advocates, we are provided with sort of content which would use, because through the resentencing, convicts and the victims were able to tell their story, really touching stories. But one common, because a convict and a victim would tell different stories. But what was common, the coordinating aspect was that everyone would find that the death penalty was not useful in any way. And that was a key aspect in terms of advocacy. In concluding the resentencing project, Cornell University published a survey which became part of our advocacy document, where it told the stories of village headmen, traditional leaders who are key in terms of opinion influencing in Malawi. And this survey, the findings were that 94% of the chiefs found the death penalty not useful in any way. And this was very critical. Now, the fact that the resentencing project, despite that Malawi was under de facto moratorium on the death penalty, was able to tell the experience of the death row inmate, it incited interest towards the conversation and uniting the conversation on the death penalty, largely against the death penalty. Now, coming to the Koviwa decision, Charles Koviwa was sentenced to death in 2003. This was before the declaration of mandatory death penalty as unconstitutional. And once he was sentenced to death in 2003, he appealed to the Supreme Court. And upon appealing, before the appeal was decided under the Supreme Court of Appeal in Malawi, in 2007, that's when the Cavantine decision came up. So in 2010, when the his death sentence was being confirmed by the Supreme Court, the law had changed in the context of mandatory death penalty as it had been declared unconstitutional. So this is what made Koviwa to go back to the High Court to seek resentencing since the law had changed. And when the High Court denied Koviwa resentencing hearing, that's when he appealed to the Supreme Court. And on 28th April, it's when the court decided that Koviwa actually was entitled for rehearing. But more importantly, it decided that the death penalty in itself was unconstitutional. This was a massive, as we more relate to, a massive decision in that it really protected the right to life as safeguarded the fact that death penalty itself abrogates the right to life, which is the mother of all rights. And not only does the death penalty limit the right to life, in fact, it removes the entire right. So the decision found itself within the Constitution of Malawi, and it relates to the international law. So in conclusion, this decision has further given sort of some energy and room for further advocacy, not only within Malawi, whereby the work that lies ahead is to ensure that everyone is sentenced who is resentenced rather, everyone that was on mandatory death penalty. But the court further having declared the death penalty unconstitutional, it means that the 27 people that are on the death row at the moment deserve as well to be resentenced on the context that since now the highest punishment the court can give is life imprisonment, commuting all of their sentences to life might be unfair because their circumstances different. And finally, the decision provides room for further conversation in the neighboring countries to use the Koviwa decision to explore engaging on abolition, depending on using this model, of course, of abolishing the mandatory death penalty, and then using the stories that come from these area sentenced people to death, but then using this model as it suits the context of each every country. So it's a pleasure, and we are excited, but at the same time, we are conscious that the work continues, and we look forward to ensuring that the death penalty is abolished everywhere. Thank you, Habiba, for the opportunity.
For those remarks, but also the analysis as someone who's been on the ground as well as working on this project for a long time. May I now invite Winnie to also come in and shed some light from the Kenyan perspective, referral. Thank you. Over to you, Winnie.
Thank you, Habiba. As you've heard, my name is Winnie Siombua, and I work with Reprieve, working on the Kenya Resentencing project. Now, I'm here to give you a little brief about Kenya's relationship with the death penalty and where we are with that. So Kenya has been quite shy in taking a bold stand where the death penalty is concerned. First, we've not had an execution since 1987. Yet we've always had people being sentenced to death year in, year out. So what happened is that all these people would be sentenced, and then they would be kept in the death row awaiting an execution that was never to come. So we had one of the presidents who came in after the oppressive one-party rule. And what happened is that that president proceeded to do a mass commutation of about 4,000 inmates who had been on the death penalty. And what followed thereafter was a series of commutations without the government taking any bold decision about either abolishing or, unfortunately, executing anyone who was on the death penalty. So anti-death penalty crusaders have always been on the forefront in building up momentum for their advocacy, calling on the government to abolish the death penalty, obviously for the reasons that it is cruel, inhumane, and degrading treatment. As what happens in my country is that when you're sentenced to death, you're kept in prison without knowing what will ever happen to you. But then again, in 2010, Kenya promulgated a very progressive constitution, one which was lauded across the region as a constitution that was not just progressive, but robust and pro-human rights. And in 2013, there were 2 inmates on death row who decided to test to test the constitution and push the envelope to see how the newly established Supreme Court could be of help to them. So they lodged a petition to the Supreme Court, a new, judicial court within Kenya. And in that ruling, in that petition, one of the things that they were praying for was for the declaration of the death penalty as unconstitutional. In 2017, the Supreme Court delivered a landmark ruling known as the Murwatetu ruling, simply because the two inmates, one was called Murwatetu, Francis Murwatetu and Wilson Thirimbu, were the two inmates who petitioned the Supreme Court. And the Murwatetu ruling through the Murwatetu ruling, the Supreme Court declared the mandatory death penalty unconstitutional. When asked, the bench reasoned that Section 204 of the Penal Code deprives the court of the use of judicial discretion in a matter of life and death. And as such, the law can only be regarded as harsh, unjust, and unfair. The judges also reasoned that the mandatory nature of the sentence deprives the court of their legitimate jurisdiction to exercise discretion not to impose the death sentence in appropriate cases. And also, where a court listens to mitigating circumstances but has nonetheless to impose a set sentence, the sentence fails to conform to the tenets of fair trial but accrue to accused persons under Article 25 of the Constitution, which is an absolute right, at least within the new Constitution. So following this ruling, the Attorney General was forced to appoint a task force comprising of representatives of state and non-state actors in the criminal justice system to review the mandatory nature of the death penalty. This task force focused on three issues. They focused on a sentence rehearing, they looked at the parameters of life imprisonment and the legislative reforms that were required to operationalize the ruling itself. So it completed its work in 2019, and it made recommendations that include, among others, the need to resentence or for sentence rehearing for all offenders on death row as at the time of the decision, which was December 2017. It also called for resentencing of all capital offenders whose sentence had been commuted to life imprisonment and any other offender sentenced to death after the decision in the Murwatetu ruling, but without regard to or compliance with the court's declaration, whereby a judge has not taken into account mitigating factors. And this was to apply to all who have exhausted all appeal mechanisms, because the practice then was that by the time an inmate comfortably, and I put this in air quotes, sat on the death row, they had already exhausted all the appeal mechanism. Now, with this ruling and with the task force sitting down and completing its work, coming up with a task force report which has proper recommendations on how to operationalize resentencing, there was an opening for resentencing in Kenya, and that is when our work with Reprieve began. So the resentencing space was opened, but then again there was a challenge in that the Supreme Court ruling was not clear. It was rather very clear that the rehearing and resentencing would not have to wait for the report of the task force to come out. So judges and magistrates in various courts started to apply resentencing using the Supreme Court ruling as a precedent that had been set. So again, apart from the fact that it was clear, there were other challenges. For example, there have been fresh death penalty sentences handed even after the 2017 ruling. So the reasons that sometimes are cited by judges is like that, for example, there's a lack of clarity or interpretation of the ruling as a reason for the muddled up decision, whereby you have one person deciding to sometimes apply the tenets of the Muratetu ruling before they hand a fresh sentence to somebody who's been, accused of or brought to court on capital offenses that attract the death penalty. But then again, we also have others who go ahead and issue fresh death penalty sentences. Others state that the death penalty was and is still part of the Kenyan laws, and therefore its application is quite legal. As Reprieve, we've been going to courts and we've met various judges, doing consultative meetings with them. We've met at least one of the judges who's told us that the law is the law. And as far as is concerned, the law does say that the death penalty is within our statutes. So he has got no problem applying the death penalty. And also in his court, because he's the head of that jurisdiction, that court, no resentencing is happening there because of the fact that he's convinced that the law has to be carried forth as is. Another apparent challenge is that being a new concept is not specifically prescribed in law. And this forces judges to apply it either from a case law perspective or as an implementation practice of the task force recommendations. And this has contributed to some of the laxity we see being experienced in the application of resentencing as far as we're concerned. Nonetheless, there are quite a number of persons whose cases have been reviewed, and some have either been released on the basis that they've served their term, or the others have been sent on a defined sentence, which is set to be completed soon. Through our research at Reprieve, we cannot be able to say that our research is complete because we've, had some limitations that in obtaining full data of who is in prison, on death row, who has applied for resentencing, and at what stage their application is, because of various challenges, including missing files and the COVID restrictions, because we began our work in April amidst the pandemic. So the restrictions sometimes impede our access to courts and prisons. But nonetheless, there has been no reported case of any offender whose death penalty or life imprisonment has been upheld upon review. And while the resentencing process has been generally perceived well, especially in the criminal justice sector, and of course also by a section of the public, there has been a confusion about its implication, especially at a community level. For example, there have been perceptions that resentencing equals to freeing dangerous criminals who are a threat to society. And also, victims of offenses have had mixed reactions, with some concluding that justice has not been properly served. The reactions, of course, are ill-informed, but in a society where for a long time the perceptions of justice served have been linked to a completion of a sentence or incarceration for a lifetime, they're not entirely misplaced. Now, there are fears that if we do not manage well these perceptions, the community perceptions, they might jeopardize the process, especially where offender integration is concerned. We have, in some parts of the country, a very bad culture of lynching people we think have escaped the law. So we're afraid that if we do not manage these perceptions, we might have cases of persons being lynched. And the probation and aftercare service officials that we've worked with express concern that the issuance of orders that are more or less direct releases without regarding the society will create problems. So for us at Reprieve, this has paved a way for the need to conduct community sensitization on resentencing and the process itself, its implications, and the benefits both to society and the offenders. As I said, Reprieve began its work in April 2020. And despite the global pandemic being a challenge, we, the Kenyan fellows, I work with a lady called Shali, who's unfortunately not here today. We've been able to so far hold consultative meetings with stakeholders to pave way for the proper implementation of resentencing. And one of the major outcomes of this is the formalization of our partnership with the Kenya National Commission on Human Rights to jointly deliver the project. That is the National Human Rights Institution in Kenya, and has been at the forefront of advocating for the end of death penalty, including being part of the petition, the Muratetu petition. Then secondly, we've also embarked on a file collection mission where we've collected files of all persons who've applied for resentencing from various courts and prisons. And we've recently set up a steering committee which brings together different actors directly involved in the resentencing process. They include the judiciary, the prison, the probation department, NGOs working on the integration, and advocates, among many other agencies. Now, the Malawi ruling. We are excited that Malawi has taken the right step towards abolishing the death penalty. And for us, we feel like it's the right step toward. It's a step towards the right direction, and I do welcome that ruling. And we also do note that the social justice regimes in the two countries are quite different, and therefore the motivations towards abolishing are similarly different. However, the ruling has brought hope and bolsters the momentum held by anti-death penalty advocates like myself. And mostly our sentiments are like that life is sacred, and whatever sanctions that must be put in place must bear that in mind. And it is my hope that the decision motivates our country to take a similar step, which will not only afford reprieve to death row inmates, but will be an affirmation that the death penalty is a violation to human rights. So far, there have been no debates, at least publicly held, about what the Malawi ruling means to us, but at least among the practitioners, we are in agreement that it does provide us with hope. Thank you very much for your time and for listening to my submissions.
Thank you very much for that comprehensive update, but as well as giving us another perspective of what's happening in your region and the work that is being carried out by Reprieve. Really, it resonates in the way that some of the things were happening in Malawi, in terms of, having those that are for, having those that are against. But again, you can see that even within the system itself, we have people that are resisting, and we have people that, are really for making this a death penalty something of the past, but also moving forward with the times, especially with the fact that we have ratified, international treaties, but also we have really progressive laws, especially in the country, which really point to the fact that the death penalty is a violation of human rights. So without wasting time, and for those that are just joining us, we are having a session on the abolition of the death penalty in Malawi and the trend towards abolition in the region. So we've just heard from Alexius Kamangira giving us a perspective on Malawi. He is a representative at Reprieve, as well as we've just heard from Winnie giving us the Kenyan perspective, as well as the work that they're doing in terms of the resentencing schemes. And now, without wasting time, let me call upon Kelly Kapianga, a Zambian lawyer who is working to replicate abolition in the neighboring countries. Kelly, over to you.
Thank you so much, Habiba. Good afternoon, everyone. So very exciting stuff that I've heard happening in Malawi and Kenya. Having heard that, I think Zambia is a little backward compared to these two jurisdictions, because in our country, the death penalty is inbuilt into the right to life, in that the first exception to a person's right to life is that it can be curtailed as in execution of a sentence of a court following a conviction. So on this basis, in 2000, the Supreme Court was invited to make a ruling on the constitutionality of the death penalty, and based on that particular provision of the Constitution, they said the death penalty is constitutional. Despite this, there has been a moratorium on executions in Zambia since 1998. Now, this is a speaking point for pro-abolitionists and for anti-abolitionists, because the anti-abolitionists say, well, if we are not executing anyone, what difference does it make if the law is on the statute books, right? Whereas the pro-abolitionists are saying, what is the purpose of having a sentence on the statute books which is not being executed? So that is the current situation. And I think it's also important to note that Zambia has neither signed nor ratified the optional protocol to the ICCPR, the second one, which calls for the abolition of the death penalty. Despite this, the Zambian government has, through several UN periodic reviews, committed to abolishing the death penalty the movement started quite a bit. In 2016, they commissioned a study. It was some sort of survey to gauge the attitudes of Zambians towards the death penalty, and they found quite overwhelmingly that Zambians favor the death penalty. But I wouldn't read in too much into these findings, because the way the question is phrased often determines the sort of responses that you're going to get. So when I was hearing about the developments in Malawi, I was particularly intrigued, and I wanted to know whether Malawi has the exception to the right to life that Zambia has, i.e. the death penalty. But in spite of that, the first decision that you mentioned, I can't remember what it's called, Alexius, the one which provided that the mandatory death penalty may be unconstitutional. And also, I think Winnie mentioned also the fact that the death penalty, mandatory death penalty, may take away judicial discretion to tailor sentences to suit the offender. I find that those particular decisions create an opening through which arguments to abolish the mandatory death penalty in Zambia can be made. I should have mentioned earlier that the death penalty in Zambia is mandatory for 3 offenses. So that's murder, aggravated robbery, using a firearm or using a weapon, and causing a grievous harm, and treason. It doesn't exist in any other format. So there is an opportunity using that line of thinking to argue that to the extent that the subsidiary legislation deprives the courts of that discretion to tailor the death penalty to suit those egregious offenses only, and also to sort of remove instances of offenders who may not be deserving of the death penalty. I find that that could be an opportunity to start reform in Zambia. And I should also mention that the decision in Malawi, the second one, the one which abolished the death penalty, was quite widely circulated. It's something that caused a bit of discussion amongst the lawyers. However, in the face of this Supreme Court decision, which upholds the constitutionality of the death penalty in Zambia, there's a feeling that we cannot challenge it in the manner that you successfully did in Malawi. But since this decision did not examine the question of discretion, I still feel that there's an opportunity to bring a challenge on the imposition of the mandatory death penalty. And I think there's another point that Alexius touched upon, the need to bring greater attention to the accused as a human being, as a bearer of rights, and also as the subject of his environment, as a potential talking point for abolitionist movements in Zambia. I think that's a powerful point. Because when you think about how dialogue in the criminal justice system is framed, not only in Zambia, but around the world, it's always focusing on society and the victims. Offenders are often portrayed to be animals, and therefore there is little attention on the impact of the various sentences that we have in the criminal justice system on them, which sort of makes it difficult to even bring up discussions about abolishing the death penalty. And there's also another barrier that I think is worth bearing in mind, particularly in the Zambian context. Zambia is a Christian nation. I think about 87% of Zambians are Christians. And we tend to sort of anchor a lot of our arguments as far as criminal punishment is concerned on the Bible. So we know that the Bible does prescribe, for instance, the death penalty for certain offenses, and it also calls for gradation of punishment against the offense. So it says things like an eye for an eye, a tooth for a tooth. So whenever a debate starts on abolishing the death penalty in the community, you get that biblical anchor. You say, well, if the Bible allows for it, there is no way we as a Christian nation, which is what the Constitution says we are, can depart from the biblical tenets. Anyway, in spite of all of these things that have been happening, Zambia has been working to review its criminal legislation, particularly the Penal Code Act. I was hoping Mwiba Mwenda from the Zambia Law Development Commission would have joined us to speak some more on this. But what I understand is that a bill is being prepared, and one of the things it's going to try to achieve is to abolish the death penalty and make all offenses which are currently punishable by mandatory death punishable by life imprisonment without the possibility of parole. So that's where we are at, and we have elections coming later this year in August. Whether or not this piece of legislation will pass, I think will be heavily determined by which government comes in. I'm sorry, I just saw a post that you can't hear anything. Can anybody hear me?
Yeah, can hear you so well. You're so audible.
Oh, okay, thank you so much. So like I was saying, we have these proposals, these are bills that are proposing for the abolition of the death penalty. And the way we got that to pass is by looking at that restriction in that exception to the right to life, because all it says is that Parliament can enact legislation permitting the imposition of the death penalty. It doesn't in itself create the death penalty. So what we are trying to do is to take out, to sort of get Parliament to take away the death penalty, so that although the Constitution recognizes that the death penalty can be imposed as an exception to your right to life, if it doesn't exist on the statute books, then the courts will not be able to impose it. Now that is meeting quite a bit of resistance, even amongst practitioners and the judiciary. And I think it's also a very short-term solution, because as long as that exception exists in the Constitution, any change in government may result in its reinstatement. And we know that criminal policy is an easy go-to for most politicians. So if we have certain offenses being committed already, and some of the politicians in the past raised the point of the moratorium as a point of weakness for the incumbent. So there were we've heard politicians say things like, well, if I came into power, I would sign all the death warrants and stuff like that. So I feel like although we are moving towards abolishing the death penalty in our subsidiary legislation, the fact that permission to enact legislation providing for the death penalty is in our Constitution is going to always linger. And also the fact that we have never taken steps to sensitize the community, to get a buy-in of the community as to the various reasons why we shouldn't have the death penalty on our statute books, means that politicians may use the death penalty or its abolition really as a talking point, as a basis for getting political clout, and then reinstate it as time goes on. Another thing that really concerns me about abolishing the death penalty in Zambia is the high incidence of extrajudicial killings. So although there is officially a moratorium on executions, it is not unheard of for law enforcement to go out in the community and murder criminals. So my fear is that we do have the death penalty on paper as almost a symbolic gesture to allow for the venting of anger towards certain offenders, and its removal from the statute books without getting the buy-in of the communities may, increase the incidences of extrajudicial killings. Last year, we had spate of murders. It's popularly known as the gassing incidents here, where people would go into homes and chop people up. In retaliation, we had vigilantism, people who would get murdered by the side of the road on suspicion that they were the ones who were causing the murders. So without tethering that vigilantism in the country, my concern is always that taking away the may have a displacement effect in increasing the rates of extrajudicial killings. So yes, thank you for the opportunity to share with you about the current fight against the death penalty in Zambia.
Thank you, Kelly. It just shows that I think there's a lot of work that needs to be done in the region in terms of really the abolition of the death penalty, and the trends really that are being discussed today on this session are very critical, in the sense that we know that I think we are at different levels when it comes to the work, the advocacy work that we are all doing in our countries. But I think there is hope for us as advocates that with the positive trends that are emerging, we can all reach a point where we can have the mandatory death penalty on our law books and also in our jurisdictions. I think at the moment, because we are also running out of time, I will invite Aurelie Odadli to come to open up the session, maybe with the Q&A. If there are any other questions, I think this is the time, because I noticed that Fulgence was meant to join us. I don't know if he's online, but I don't think he's online. So let me allow Aurelie Odadli to open up the session for a Q&A.
I think I'm here.
Habib Fulgence has managed to join.
Oh, Fulgence, you're here. Fulgence, you're here. Well, welcome, Fulgence. Welcome to this session. We've just had Alexius, Winnie, and Kelly all give us a perspective of the work on the abolition of the death penalty trends that are occurring in Zambia, Kenya, and Malawi. Now we open it up to you to give us also a perspective of what's going on in Tanzania. Just bear in mind that we are running out of time because the session is meant to finish at 5:30. Yeah, you're welcome. Over to you.
Thank you, Habiba. I was here since Alexis. I don't know what's happening. You are not noticing me. So yes, I've been following up from the beginning. Camera. Yes.
Yeah. Yes. But over to you, Fulgence. Apologies for that.
Okay, thank you, Habib. Of course, the situation in Tanzania, I think it is unique in its own, because, you know, as historically, Tanzania had no Bill of Rights in its constitution. The Bill of Rights was introduced in 1984, and there was a transitional period of almost 10 years. In 1993 is when this Bill of Rights became enforceable. So in 1994 is when we received the first remarkable decision on the death penalty. Of course, Tanzania has a mandatory death penalty and for the offense of murder. And in 1994, we received the first decision in the very famous case of Mboshu, which was quoted with approval in Makwenyane case, in which the High Court held that the death penalty is unconstitutional and is a cruel and degrading punishment. But this didn't live long. This decision was reversed by the Court of Appeal. But the High Court decision has become so popular in such a way, it has been quoted so many times, and they forgot that the decision was reversed. But our mission to fight for abolition of death penalty or mandatory death penalty, we have been doing some advocacy work, but in 2008 is the first time we filed the case in court challenging mandatory death penalty in Tanzania. We partnered with the Death Penalty Project UK. We later on came to know Cornell Center for Death Penalty and the Reprieve. And ever since, the situation hasn't been that much good because the case gets lost in court. We filed another one, and we lost it at the High Court. And we appealed in 2009, and to date, the case has never been heard. While we were fighting in this local court, we had another case which was decided at the African court. Ali Rajab case is a very famous case right now in the region. In this case, they abolished the mandatory death penalty in Tanzania. But the only problem which we've been facing now is implementation of the Rajab case in Tanzania, because even immediately after the decision being issued, I don't think the Tanzanian government was pleased with the decision, so it's when we withdrew from the declaration for the direct access for the individuals and CSO to the court. So to us as position it stands, we are the only country in the region, because Uganda is abolished mandatory death penalty, Kenya the same, Rwanda and Burundi don't have death penalty, and you can see our fellow in Malawi, they've progressed so much. So the situation in Tanzania is the only thing which is now we are supposed to pursue is to make sure that our appeal, which is pending the Court of Appeal, is heard, or to make implementation of the Ali Rajab case of the African court. And we have been working tirelessly with the Cornell Center for Death Penalty and Reprieve to make sure that this decision is implemented. And there is so much going on the ground in terms of at least obtaining advisory opinion on how to apply on some other similar cases pending before the court, and to lobby with the government or to advocate with our government to make sure that this decision of Al Rajab, it is implemented and the mandatory penalty is abolished in Tanzania. So far, a situation is stand for the interest of the time. We still have death penalty, and we still have much to go as far as this region is concerned. Thank you.
For that a brief progress update, but also I think it helps us to understand and to buttress the point that indeed I think we are at different levels, and that the trend toward the abolition of the death penalty in the region is not as easy as it seems. There are so many roadblocks and there are so many challenges, but I think the positive thing that is coming out, the takeaway for me, is that we have advocates on the ground that are really working so hard in terms of ensuring that the abolition of the death penalty in our countries is effected, albeit with challenges. But again, I think what is also very clear is that there is a huge need for mindset change. But again, also, I think there is need indeed to really make sure that whatever our countries have ratified in terms of international human rights law, it must really match the rhetoric that is on the ground. So right now, I'll hand it over to Aurélie or Dudley for a Q&A session just before we close off. Thank you. Unless, of course, there is anyone who wanted to make a comment, an observation, or just to buttress a point. Over to you, Dudley.
Oh, wait. I just wanted to make a point in terms of saying the decision in Malawi that declared the death penalty, the mandatory death penalty and constitution is the Kafantine versus Attorney General. And further, when I had a look at the constitution of Zambia, there's a similarity with regards to the aspect where the death penalty has been seen to be sort of something that can be applied without it being unconstitutional in a way. So I think it's also a takeaway from me to have further conversations with Zambian colleagues. So thank you for bringing that up, Kerry. Back to you, Aurélie.
And maybe I should take this opportunity to also thank all the speakers who have really given us some insights about the trends toward the abolition in the region. And we have also got a lot of things that we need to do in terms of moving forward with our advocacy. And I just also want to agree with Alexius and some other colleagues on the line who actually said that there is need to really broaden the conversation, because we know that the attitudes of some of our judicial officers is that which is sort of like conservative in terms of really viewing the issues of the death penalty. So there is need for advocacy work, but they also need to share information. And I think platforms like this offered by the World Coalition, as well as our sponsors who sponsored this session, Cornell Center on the Death Penalty Worldwide and the East African Coalition Against Death Penalty and Reprieve, must continue having these platforms so that we can share information, advocacy tips, but also just document the best practices that are needed for us to make sure that the trends are being mapped, but again, that advocacy efforts are being complemented in the region and worldwide. So thank you very much to our sponsors for this particular session. And thank you to all the speakers today from the region.
Thank you so much for having me, everyone. And like Alexius mentioned, I think there's some dialogue to be had amongst ourselves about how you managed to go around that particular provision in the Constitution. Thank you.
Thank you, everyone, as well. It was a pleasure speaking here.
All. Bye for now.
Bye-bye.